Aging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome back, everyone, to the Aitken Robertson YouTube channel. So one of the top concerns for clients often revolve around whether they should take the stand during the trial. Today, we have counsel Phil Sells with us to shed a little bit of light on this. Phil, can you shed some light on how this decision is typically approached?
When you're looking at a case and you're deciding whether or not you want to testify with your lawyer, one important consideration is, what does my testimony offer? Does it advance my case in any way? And what's good is to almost draw out a risks versus benefits flowchart, almost, to show the advantages and disadvantages of testifying. So you can really understand what, if any, risks you have, and you can understand what the possible benefits would be if you chose to testify. In an internet case, often testifying doesn't make much sense because it's the Crown's onus to prove beyond a reasonable doubt that you crossed a criminal threshold, and you did so by using the internet. And in a lot of internet-based cases, identification of the user is almost always an issue. And so let's say, hypothetical, I'm someone charged with an internet crime, and the Crown, we get to trial, and the Crown is trying to prove that I was the individual either behind the computer or the phone or what have you. My defense may be that, yes, I was the user, but I certainly didn't do X, Y, and Z as alleged, right? But without my evidence, the Crown would have no evidence that I was even the user at all. Just a hypothetical scenario. The decision would really hinge on whether there's a problem enough with identification of the user and to simply hold the Crown to its onus. If there isn't a big problem for the Crown proving identification, then it may make more sense for someone to take the stand and give their reasonable explanation as to what was done with the phone and when they had it and how they used it, and express their shock to learn that whatever device was used to do something illegal. It's really on a case-by-case basis, but my point is, use of the internet, often it is difficult to prove that one particular individual was using the internet at a particular time.
So when does a client usually need to make up their mind about testifying or not?
Well, a client doesn't need to make up their mind until the very moment the defense calls their case, and even after that, if they're not the first witness. My rule of thumb is, if it's even foreseeable that a client may be testifying, we should be planning as though they will testify for sure, and they should be ready to testify and understand what is going to be happening in the court and how the direct examination is going to work and how the cross-examination is going to work, and understand the areas that they're going to be asked questions, that they're essentially ready to testify. So my rule of thumb is, you must be ready to testify, but you don't have to decide until the Crown closes its case or even after that. And the reason for that, Melanie, is because often a trial is not what it is anticipated to be. You see a trial as it may look on paper, but There may be an issue that causes someone to not testify or testify depending on how the evidence actually comes out during the trial. A trial is a constantly evolving beast and you need to be adaptable. The big point is, to answer your question, that you have a plan, but you don't need to actually decide until the moment you're either ready to take the stand or not.
Thank you so much for all that information, Phil. And thank you for everyone else joining us today on the Legally Speaking Aiken Robertson YouTube channel. So don't forget to like, subscribe, hit the notification bell. And until next time, stay informed, stay engaged, take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aiken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.